the Center for Art Law's second event, part of our Art Law in Paris lecture series. We started earlier this spring thanks to our fantastic legal fellow, Rachel, bringing art law topics to Paris in order to learn from our French colleagues. And if you are interested in anti-money laundering conversation we had back in March, the program is recorded and available online, as will be this program that is dedicated to AI and copyright discussions. So first, we're going to start with disclaimers. All the program content that we're sharing with you is for your informational purposes only. If you need an attorney, we encourage you to reach out to attorneys who are participating or other attorneys, but there's no attorney-client relationship being formed. And there is a handout that our team members have put together that we encourage you to take a look and use and review again for informational purposes. So what is a New York-based, really Brooklyn-based nonprofit organization doing in Paris? Well, we are international, and the topics that we're discussing are international, and there are many things that we can share as well as learn from our colleagues. So a couple of words about the Center for Art Law. If you haven't attended our programs in the past, we love learning, and we do a lot of programs on different subjects that have something to do with art law, from antiquities to metaverse. If you have questions, please reach out. If you're looking for internships, take a look at the deadlines. We're very strict about when we accept new applications. And if you have questions that are art law related, please again, consider getting in touch with us. Some of the events that we have done in the past and that we're offering in the future are archived. We have a big conference coming up later in the month in New York, and it will be a hybrid as well, about art law, the story. Take a look, and if you want to join us, please do. And if you're interested in the works that we've done in the past, we have been archiving our webinars such as the Celestial Art Law program and some like a digital series. So again, these resources are available for you. There are benefits for learning on ad hoc basis or as members, so you can take a look at these resources. One of the new resources that we have put together is a Case Law Corner, is a searchable database of 680 cases now, a fair number of them about copyright law, etc. All right, that was the logistics. The program is being recorded. You have the handouts, and without us jumping in further, I'm gonna launch a little poll to find out where you guys are coming from, because now you know a little bit more about us, and we'd like to know a little bit more about you. So there is a poll for those of you guys who are online. Please take a minute and tell us where you're from. Is it US, Switzerland, France, somewhere else, and whether you're students or not. You should be seeing it on your screens now. Okay, so as I promised, we're talking about AI and copyright law, and I have a feeling that many of the people who are joining us are not new to this subject. You guys probably know much more than I personally do about AI and copyright law, but we have a fantastic panel of speakers who are going to share their knowledge. And I thought that to get everybody on the same page, if you are a novice in this area, what is this monkey business, the copyright and the creative process in the 21st century? You might have seen NFTs, or you might have dismissed them, but there have been issues with that digital art form copying materials. I'm going to end the poll now. Thank you for those who have participated. There are many cases involving copyright disputes and traditional art makers, some of them deceased, like Warhol case that the Supreme Court heard recently. And we're seeing a lot of debates and questions and lawsuits involving art created with a new tool. I mean, it might be new to us lawyers, but it's not new to the makers. Right, there are lots of different things you guys are seeing, sorry, on the screens. Okay. Fantastic. So, the speakers, we have been working on the lineup, and we apologize for any confusion, but we have extended our panel, and we have, in addition to Professor Dusollier and Intel Razou, two more speakers who will talk about the state of the UK copyright and AI cases, and we're being joined by our Director of Legal Research, Atreya Mathur, who is going to talk a little bit about US cases that we will, we're thinking of hiding this fact that US is a very litigious society and there are many lawsuits happening there, but I think we shouldn't do that, and so we decided to share with you this information. All right, so again, special thanks to Rachel Sundar for the work in organizing this. And let's look at some AI art. Two photographs. They might be eerie, they might be new to you. You might have seen them or not. This one of two women hugging an octopus is by a Swedish photographer, Annika Nordenskjöld. Or is it? Because I don't think you've ever seen anybody hugging an octopus before. This is an AI generated or created artwork. And another photograph of very eerie two women by German artist Boris Edelgesen, who was offered a prize for his submission to the Sony World Photo Awards. And he said, thank you very much, but this is not a photo. This is a work of art created by AI, and it should not be deemed a photograph, and it should not be receiving this award. All right, so we can be fooled. Artists are aware that they're doing something new, novel, and they are also aware that they have certain rights, even if we might not be as avant-garde as they are. Sorry. There we go. So as AI-generated art is being made, this one made the news in the legal realm, called A Recent Entrance to Paradise. The work was created in 2016. I'll tell you who made it in a moment, but the lawsuit was resolved, at least for the moment, last summer. This is a case called Thaler versus Perlmutter. Thaler is a computer scientist who created a machine called Creativity Machine, and he tried to register a work of art, this tunnel through some flowery mesh, I guess, as a work of art created by AI. And the Copyright Office said, thank you very much, but we can't issue copyright to a machine. And Thaler was very adamant. He wanted the machine to have the copyright, not him, the code writer and generator of this work. The Copyright Office said there needs to be human authorship for a work of art to be copyrighted, because copyright law is trying to encourage productivity, and machines don't need to be encouraged. Non-human actors need no incentivization to produce works. And so for the moment, this case, in my mind, settled some issues, but I think artists and creators and AI developers are trying to advance the arguments and protect their economic interests. We are in Paris, so when we talk about copyright law, it's always nice to have a nexus. You might be familiar with this contemporary artist, Jeff Koons. He has been inspired by lots of different content. Back in 1988, he created a number of sculptures for a show called Ushering in Banality. I think he definitely ushered in banality, and he infringed copyright very actively, effectively being sued at least 5 times, twice in France, because he took some of the works by French artists and created his own sculptures based on that. He also took a photograph of Art Rogers. I think he was an American photographer, and made this series. Actually, his studio made this series of sculptures. Koons was accused, rightfully, in my opinion, of copyright infringement. because he was imposing on economic rights of other artists. For US, that's what we know, and we're hoping to learn a little bit more about the state of the copyright law in France and in the European Union in general. But in the United States, the copyright law is created by the US Constitution. There's a clause about promoting the progress of science and useful arts, which ultimately resulted in a Copyright Act of 1976. That's the latest Copyright Act in the United States, which indicates what is protected. And once something is protected, like a work of art with human authorship, what kind of damages the copyright holder can hope to get in case of an infringement. And that is the issue of the human authorship that we're now running into vis-a-vis artificial intelligence creation. Also under copyright law, there is a concept of fair use, which I think exists in other jurisdictions. And fair use says, yes, if there's copying, which is an unauthorized copying and effectively infringement, there might be some circumstances when this kind of infringement is desirable. And we could say maybe art created using artificial intelligence, new tools, is a desirable output. And so perhaps it's fair to be taking thousands and thousands of copyrighted works in order to generate something new. So this is the debate. Is there infringement and is it fair? I'm going to take you back to another very cute monkey. It has really nothing to do with artificial intelligence, no human intelligence. There was a case in 2018 where a human tried to get copyright to a photograph that a monkey took. And the Copyright Office said, no, that's not possible. And the Copyright Office also issued a very clear explanation that certain works will not receive copyright because they're not original works of human authorship. And the Copyright Office indicated that they will not register works produced by nature, animals, plants, and maybe now artificial intelligence. So here there's a monkey selfie that is not in copyright. This is an interesting copyright case, very important, seminal. It leads us to, again, the present state of the copyright law, where a human took photographs and another human took their photographs. That's Patrick Carriou, a French photographer, and Richard Prince, an American appropriation artist, who took a lot of Carriou's content, enlarged it, modified it, made it into collages, and effectively infringed and got sued. After the case was ultimately settled, I invite you to read the case decisions in lower and upper courts. But after the case was settled, Prince received his works back, and he said, I'm seeing them for the first time in 5 years, and what they should have sued me for was for making shitty paintings. The question is, if AI is creating bad art, can you sue it for that or not? Probably not. But to put things into perspective, I'm going to cede the floor to Séverine Dusollier. All the bios of our speakers are in the handouts. Again, I encourage you to take a look at them after the program and use them in your research and your practice. Thank you very much, Séverine, for joining us. I'm going to turn the podium to you and welcome.
Thank you. Thank you very much for having me. I will share my screen. And again, I lost my, yes.
Please let us know if the sound or anything else is giving you any trouble. If we can fix things along the way, let us know. But Séverine, we can see your...
You can see the presentation? Okay, great, thank you. So thank you for inviting me to this. So I will try to just outline a few copyright issues that generative AI is rising, and to look at them from an EU perspective, that might be a bit different from the US, even though I will look also at some US cases to illustrate what is going on, because the questions are arising in a similar way, of course. So you all know about generative AI and how it can create everything in every type of creation, text, images, videos, music, etc. So of course, what will interest us today is visual arts, photographs, images, etc. And generative AI is actually creating two types of issues in copyright. The first one is the question as to whether AI-generated work can be protected by copyright. And we don't have a lot of case law so far, because one of the key rules in copyright all over the world is that copyrighted work is protected as soon as it is created. So you don't need to register it or to ask for protection, etc. So it means that to challenge the protection of a copyright work, usually you need to have a litigation, a copyright infringement by someone else, and then the question of protectability of the work that has been infringed might be raised. So that means that actually we don't have a lot of case law. There is one, sorry, I went too far. There is one case coming from Beijing that was about two AI-generated images, one that was claiming protection by copyright and another one that was claimed to be infringing. And the Beijing court decided that the generative AI work was a work of authorship and was protected by copyright. But I will pass that case because it might be a bit specific, and also I don't know a lot about Chinese copyright law. You've been shown already that image of the recent entrance to paradise. It was the first generated AI images that was asked for copyright registration in the US. And the US is a specific case because it still has a condition of copyright registration of the work to the Copyright Office, not to be protected by copyright, but to be able to benefit from some possibility for enforcing your copyright. So that means that you still have this step in the US where you have to register the work in the Copyright Office, and so the Copyright Office can say no and can just refuse the copyright protection. So this explains why you have so many cases coming from the Copyright Office right now. So the first cases, as Irina said, has been denied by the Copyright Office and then by a court. And in the court decision, the court really insists on the factor of human authorship and says they need to be a human as a creator, a machine. It cannot be an author. The same was true for the other case, the Théâtre d'Opéra Spatial. The image on the right side won a contest, an art contest in Colorado, and then it registered the image. The image was registered at the Copyright Office that refused because it was generated by AI, despite the fact that the artist, the creator, said that he spent hundreds of hours finding the right prompts, testing different things, arranging the image, etc. And here the Copyright Office says that the prompting is not enough. Even the prompting is creative. Even if it takes a lot of time, it's not the prompt that creates the image. It's really Midjourney that creates the image, and it is a machine. It cannot be a creator. There are two other cases that interest me a bit more, because I think they've raised very difficult questions that might be the same in Europe very soon. The first one is that one. It's a comic book that was done by a young artist, Mrs. Kashtanova, and on the cover of the comic book, she indicates that Midjourney is also a co-author. So she made the images using Midjourney, and it is a comic book for 16 pages, I think. What is interesting here is that the Copyright Office first granted copyright, then it learned that the images were actually generated by AI, and then it changed the decision and said that actually the author could get copyright, but only on the thing that she created herself, meaning the text, the selection and arrangement of the text with the image. But in no way she could get a copyright in the whole. So actually it means that she will get a copyright on very few things, only the text and the arrangement of images. So the Copyright Office just separate the work into different things that are uncopyrightable and things that could be copyrighted. another separation that the Copyright Office does is for, oh, sorry, I have a problem with with that image. And here the separation operates at different stages of the creation process. That image was registered before the Copyright Office that refused, and that actually said that that image was generated from a photograph that was taken by the claimant, the creator, and the creator submitted that image to a generative AI tool by asking it to transform it into the style of Van Gogh. And then the Copyright Office said, but then if you do that, you create a derivative work. And you, as an author, Mr. Sani, who was the author of the photograph, you might be the author of the photograph, but the process you subjected to is actually a process that is done by the machine. And so we have to judge whether that process is a derivative work that is original enough, and the Copyright Office refused, which is a bit strange because it might be similar, not exactly, it might be similar to the fact that you Photoshop something that you have, a photograph that you've taken, and that photograph, that Photoshopping process is considered as a derivative work of your photograph. It's not, it's in a way artificially separated from your creative gesture in the first hand. So this is really interesting because it shows that the Copyright Office and maybe courts in other countries will try really to make the machine or might give the machine a very predominant role in a creative process that actually a lot of artists are experimenting by using AI tools as they would use any other technique. So that will be the case in many, many countries where those countries actually insist on so Europe, Australia, Canada, that they all have very important cases that says that the condition for copyrightability is the presence of a human author and the presence of creative choices. So we might go in the same direction than the US cases. And I think that the key point would be at some extent to decide whether the AI is a machine that produces images of its own, or is it only a technique that it's used by creators, by authors to create works? And that question was actually raised 1 century ago when photography started to claim copyright protection. And you can see in case law in France, particularly, that at some point the judges changed their discourse to abandon the idea of the photography as a machine to make it only as a technique. And I think that maybe in next years, we might see in some cases, so I'm not saying that images that are completely generated by AI should be protected, but at least that when AI is used by artists, by creators as a technique, as a tool, we might maybe be able to welcome those creation into copyright. The second question that is arising is...
Bonjour, je vais 48 rue Cambon.
The other issue that is arising is the fact that so all the claims for copyright infringement, because they are copyright
Excusez-moi parce que je suis en train de...
the image in the data set.
Près du...
Okay. So this is an issue that you have certainly heard about. That you have a lot of, I'm sorry, I'm losing it a bit, that has been actually triggering a lot of lawsuits, mostly in the US. So I think we are about 20 lawsuits in the US coming from different type of artists, from image artists, writers, novelists, journalists, etc., the music industry. And those, all those cases are actually trying to get or to stop generative AI from using their images in their data set on which they are trained, and also trying to get compensated for that use. So I will not cover all the cases, but they are almost similar. The first case was started by 3 illustrators. One of them is Sarah Anderson, who's produced very simple comic books. It's the image A, and she is claiming that actually generative AI can lead to generate images like the one on image B, that would be a copyright infringement, a copy, a reproduction of her work. Another type of cases that is very interesting is the one that has been started by Getty Images. And here, Getty Images is claiming about the same, the fact that the use of Getty Images in the data set might generate specific images that will be also reproduction or derivative works of specific image in the data sets, in the image database images of Getty. So both cases are interesting because they use copyright claim in a very different way. So actually, based on copyright, the thing that you can say in those cases, or the claim that you can make, are different. First, you can say that the reproduction of your work in a data set is an infringement of copyright. The second argument is the fact that when works are in the data sets, the training process is scrapping that data set, and by doing that, it is making a reproduction of those works. I will go in details in a moment on each claim. The third claim is the fact that a specific output from generative AI process is a derivative works of some works that are in the data set and they are used as inputs. This is the Sarah Anderson case, if you wish. And then we start to see other elements that are not, strictly speaking, based on copyright grounds, or they are related to copyright, but they are more vague in a sense. They are not completely in a case of infringement. The first one is the capture of value of creative works. And this is one of the key arguments in the Getty case that says that we have invested a lot in setting up that millions of images database. And what generative AI is doing by extracting images from our database is capturing our value and our investment. So it's more an economic argument, if you wish, an unfair competition argument, but it might have some difficulty in being encapsulated in a copyright law argument. And the last argument that is very important, actually, but it's not legal as such, is the fact that the creators are suffering. And some creators might suffer more than others, for instance, illustrators that start to see that they might get less commission for their works because generative AI can do the job at their place. And so there is this question of economic subsistence of creator that we should pay attention to, even though it might be difficult to make copyright answering to that question. Okay, so first, are works reproduced in data set, and is it a good ground for copyright infringement? I should say yes. So it might be that indeed, when you have the constitution of a data set, you are copying works or images, etc., to put in the data set. So there should be actions against the data set producers, as the Lion data set that is massively used. But so far, you don't have, in some of the US cases, you can see that the dataset producers are also in the case, but more often they are not. And I know that there is a case maybe in preparation in Germany against the Lion producers of the dataset, because I think that this could be a good way to go, even though it might not get a lot of compensation of damages at the end. The second argument, it might be more difficult, but this is one that is used a lot, is the fact that when scrapping the data sets while training and building the model, works are reproduced. So the generative AI industry constantly said that it's not true, that no works are reproduced at all, but there is in copyright law the issue of what we call the temporary reproduction, that is in Europe very technically defined, meaning that each time that you even use a work in a digital form, you make a copy out of it, even if that copy never stays, even if it's just very volatile. That temporary reproduction is undecided in the US. So it might be one of the outcome of the US litigation that actually the US court might decide that there is some reproduction there, but I think it's uncertain. In the European Union, actually, the issue has been solved in a way, because we have an exception that actually covers that act of scrapping the data set when doing AI training. And I will say a few more about this. In the European Union, we have first the copyright directive on, so the directive on copyright in the digital single market, that is a directive of 2019, that I went too far. I'm sorry, I have a technical problem with my PowerPoint that does that sometimes. So that directive in 2019 has an exception to copyright for text and data mining. So compared to the introduction about fair use, in Europe, we don't have the broad notion of fair use. We have a specific list of exceptions, and each exception to copyright has to comply with a very strict condition. And this is one exception that has been enacted in 2019 in Europe that actually covers text and data mining, so the technique that aim at analyzing text and data. And that exception was put in place first to enable scientific research that increasingly use text and data mining. But then at the end of the process of adoption of directive, the European Parliament also said we would need that also for AI. And so the exception is broad today, it's Article 4, and it's exception for text and data mining for all other purposes. On two conditions. First, you should have lawful access to work. So it means that you cannot mine unlawful data set, like for instance, Sci-Hub for scientific publication. And the right holders, copyright holders can opt out. So they can decide that their work will not be part of the exception. That exception was adopted actually before the advent of generative AI. And when generative AI started to emerge and that we could witness what it could do with copyrighted works, the copyright holders started to panic, literally. And they said, oh, but that exception was not aimed for that purpose. So if we agree that that exception would cover the use of copyrighted work for generative AI production of new images, that will be the end of copyright. So they started to organize in two directions. First, they asked the European Commission to reopen the directive and make it not applicable for text and data mining. And then the other side, there was the discussion at the time of the AI Act that should be released in the next days. And they said, okay, we should also invest the AI Act and try to solve the issue. And this is what they did. And maybe they made a mistake, I think, because this the AI Act said, okay, indeed, generative AI is covered by the Article 4 of the Copyright Directive of 2019. So there is an exception for the use of work in the process of generative AI, but the providers of generative AI models need to first put in place a policy that enable the right holders to opt out, as it is provided in the directive on copyright, and they should also make some transparency about the data set that they are using. And that means that today, the copyright holders are just frantically trying to opt out. So you can see a lot of things online that a lot of collective managing organization like ADAGP in France that is in charge of visual arts that actually opt out. So they say, we opt out, we don't want generative AI to use our works. But for the moment, it's a bit disorganized and you don't know exactly how it will work. On the right side of the slide, you see what has been put in place by OpenAI. That is a sort of form that enable you to opt out, but it has to be done right holders by right holders, and it might be complicated for collective management organization to do it for whole repertoire of works. So for the moment, we are at a phase where nobody knows exactly how it will be enforced and how it will be really working out. That raised the issue, the last issue that I want to raise. I still have 1 minute. Yeah, okay. So one of the last issues. So the other issue is whether you can claim that the output generated by generative AI is a derivative work from your own work. So this is, as I said, the claim that Sarah Anderson is making and other artists or Getty Museum is making. Actually, this is very difficult to claim. So they are using a lot of different arguments. They said that, because of course it's difficult to say out of millions of images that generative AI is using, the image that you produced after prompting something will be a derivative work of one or two specific copyrighted works. But copyright holders are trying, saying that yes, Midjourney, for instance, is a collage tool. So they are remixing, reassembling copyright works of others. Of course, you cannot really predict what image will come out of the input, but at the same way, if the copyrighted work is in the data set, it means that it will have an influence on the output in a way. They are trying to use some technical explanation, but they are really not successful so far, because in the decision that we have already, all the courts say you haven't proved anything. You have to prove that a specific output would be substantially similar, that is the legal criteria for derivative work in the US, to your work, for us to decide that there is an infringement because this is a derivative work. And of course, this is completely fair because, sorry for that, if you, for instance, if you make some test, if you prompt female by Sarah Anderson or something else, you might get a lot of different outputs that will not be substantially similar to the work of Sarah Anderson. Maybe some will be in the style of Sarah Anderson, but style is not protected in copyright, whether in the US or in Europe. So it might be very difficult to say that there is a derivative work. Actually, the problem is that the generative AI is creating a crisis of the image and of the work of authorship. And here I will be very quick, but I like this article by an artist, Ito Style, that is called Mean Images. And actually, she tried to find all the images of her that was in Lion 5B, which is the data set that is used by Midjourney. And then she asked Midjourney, a stable diffusion, produce an image of Ito Style. And the image that she got was this one. So this is why she entitled her article Mean Images, because of course the image is not nice. It's not a nice image of her, it's a mean image. But at the same time, it's really also an image that is a mean to say something, but not an image to represent something. And this is the source of the problem. It's the ontology of the image has radically changed, because image in art, in culture, they are cultural representation. In generative AI, images are just statistical renderings. They are not representative anymore. They are not represent any reality. They are just produced as data, as raw material. They are constituted by statistics, by patterns, but they don't represent any individual authorship. So there is a clash, a very big clash between what a work of authorship is as an individual expression of authorship and what a generated image is, just a composition of data, actually, and of statistic. So this explains maybe why the next argument might be just to look at the economic arguments like Getty is doing, or like the New York Times is doing for its database of articles, to say that actually what generative AI is doing is just capturing the value of the masses of works that is a data set and not the specific work of art. And that might work, but that would mean that actually we're not talking about copyright anymore. We're not talking about individualized works of authorship, but we are just talking about compensation for value gap and for investment. And even though I want to be able to find some compensation for creators, I fear that it might not be the right argument, or it might be not the right strategy to develop. I will stop here. Thank you.
Séverine, thank you very much for your presentation. It's very thought-provoking and raises a lot of questions. And we were exactly hoping, copyright is about economic interests. And what I've heard from American lawyers is, well, our copyright law is from 1976. Our Congress is not going to get around to fixing it anytime soon. We have courts dealing with these disputes, and EU is currently working on the AI Act, and so let's look at what EU is going to do with vis-a-vis artificial intelligence. And it feels that European Union or Europe is looking to what US is doing in the courts, but also thinking and moving perhaps faster in terms of legislating. Thank you very much for the examples that you shared with us. The Chinese case is quite interesting, the data set that you mentioned. There's a question that was posed about a special data set called Boto. I don't know if you're familiar with it, that an AI artist, Maria Klingerman, is creating. Do you have any knowledge of that experiment?
Which specific data sets? Sorry, I didn't get it.
Boto?
No, I'm not familiar with that.
So you mentioned that there are data sets and there are tools. So the question is it a machine or a technique? And your reference to photographs, it's very interesting that we had photography kind of generating, or artists generating photographs and then saying, ha, we fooled you, they're not really photographs. But it's an interesting tool. And so from the arguments that you are making as a scholar, as an academic, we see that this industry is quite active and there are real businessmen and economic interests being touched upon. So we're gonna switch gears and we're gonna hear from our second speaker, Mathilde Brezou, and who's with Phil Fisher Paris, and Noor Kadim, who's with Phil Fisher London, are our very kind hosts. So many thanks for making this program possible in person in your beautiful offices here in Paris. And Mathilde, if you don't mind taking on the discussion of, well, when you have an artist coming to you and saying, my art has been used in the data set, or when you have a client who says, I would like to create a data set and then generate beautiful images and then monetize them, how do you go and work from the theoretical and the precedent to the present?
Yeah, I will try to respond to all these questions. So my presentation will be really more dedicated to artists or creative agency, and I try to be really practical. Yes. So yes, I will talk just quickly, remind you how generative AI works. I will talk about the risk posed by generative AI with regard to copyright. Then we will see how creators can propose the reproduction of the work, how to mitigate risk when using generative AI, and how to protect potentially non-original work generated with AI. So just to remind you quickly, how does generative AI work? So generative AI work are trained on a very large amount of volume of data, as Séverine told you, that we call the training data or the input. And based on this prompt and the training data, the generative AI will generate an output, so a new content, that can be used by the user. So here you have the key point of the AI system. So you have first the training data, the input that come into the AI generative model. Then the user made his request, called the prompt, and then you got your result, which is called the output. What is important to know is most of the time, all the information that you include in your prompt could be reused as training data. So I will talk later about the issue that it could raise. So what are the risks posed by generative AI as regards copyright? Séverine already explained that as generative AI systems are trained on data that are extracted from internet, all this data, the training data, may reproduce an existing original work and then could constitute a copyright infringement. And what is really difficult for creators using AI system is that it is almost impossible to know if the output is infringing or not, as the sources as never mentioned by AI system. Who is liable for copyright infringing AI output? Anyone
Similar
reproducing.
to things I was thinking, yeah.
So anyone reproducing AI output may be liable. So therefore, AI operators may be liable. But you will see, if you read all the term of services of all the AI operators, they generally include a disclaimer indicating that the user is solely responsible for the use of the output. So Séverine introduced you and explained that you have a European directive which provide the exception, the data mining exception, which is an exception to the copyright protection, which allows AI operators to extract data from internet. Okay, so all AI operators are relying on this data mining exception to use and extract training data. But there is a way, very important to know for all creators and creative agency, there is a way to oppose the reproduction of your work if you opt out. So the question is how to opt out in practice. You can use technical means. There is now a web protocol which has been specifically created to not to block the access to the websites, but only to avoid any reproduction of the content of the website. So this is a web protocol. You can find further information over internet, or you can ask me later if you want. Séverine also talked to you about the means proposed by AI operators. For instance, OpenAI proposed a form that could be filled out by any artist to oppose the reproduction of their work. You can include appropriate provision in your condition of services, your website, or you can directly contact the AI operators. Of course, as Séverine explained you, it's true that practically speaking, it could be a bit difficult because the opt-out must be done author by author, work by work, for each work. So for now, it's not really a satisfying solution, but at least as an author, as a creator, you can oppose the reproduction of your work by AI operators. In France, copyright management societies formally opted out. For instance, the SACEM, which is the house representing authors, composers, and publishers in France, formally opted out of the data mining exception. So now the permission must be sought for AI training. And the International Confederation of Music Publishers launched a portal where all the artists and the music publisher can log their reservation of rights. So this is also a way to opt out from the data mining regulation. So advantages to opt out. Of course, this is a way to defend your IP rights and prevent any infringement of your work. And it is also a way to generate a discussion potentially with AI operators. Because we saw that, for instance, the New York Times or Le Monde opted out, and then the opt-out has been used as a kind of leverage to negotiate with AI operators for paid license. So now, for instance, for Le Monde, the French newspaper, now all AI operators need to pay to access the content of Le Monde. So it shows that the fact to opt out could be also used as a way to negotiate the payment of your content. Now I will talk about how to mitigate the risk when using generative AI. So it's true that it's really difficult to know whether the content, so the output generated through the AI is infringing or not, because the sources are not mentioned. So, but sometimes you can have a doubt, or you can think, okay, this output seems to be familiar with another existing work. So then you have to check 3 points. Are the original feature included in the output? Is the earlier creation can be recognized? Is the overall impression is the same? And then I include a quick quiz just to know your opinion if it's infringing or not. So on the left side, you have a character. It's the Ultraman. I don't know if you know him. And on the right side, you have several images. Do you think that the second images reproduce the first one? I ask you, do not hesitate to tell me what do you think. Do you think it's infringing or not? So actually, this is a real case that has been ruled by a court in China. And the court of Beijing decided that all the images on the right side were infringing the Ultraman character. So this is a concrete example of infringement that have been recognized by a Chinese court. Here, it's not a concrete example, it's just an example of image that you can create with the assistance of AI. So do you think that the second image is infringing the first one? What do you think? No? No? Yes, no is the right response. Why? Because here you don't have the original feature reproduced in the second image. This is only the idea, the concept of wrapping a baby into a bread, which is reproduced. But if you look at the detail, both images are really different. And pursuant to French law and many EU regulation, just the single fact to reproduce an idea or a concept is not infringing. Here, it is also an example of images created by generative AI. Do you think the second one is infringing the first one? Yes, for me, in my opinion, the second one is really, really similar to the first one. So it has been used for promoting a campaign for the movie June. And I think the second one is really, really similar to the first one. So it should be considered as an infringement. And this is the last example of a breach. So do you think the second one is infringing the first one? Actually, this illustrates very good a very famous case in France. I don't know if you know the artist Christophe, which is very well known to wrap the monument. He wrapped the Arc de Triomphe last year. And we had a case in France where Christophe sued another artist for wrapping another building. And the French judge decided that it was not an infringement because once again, it was only the reproduction of an idea, of a concept, but the way the building was wrapping, etc., was not the same. And here it is also an example because if you look at the detail of the second image, the way the bridge is wrapping is different. And this is only the idea which is reproduced. Now, I would like to share with you a list of do's and don'ts when you prompt. So this is once again very practical. So I advise not to include any confidential information in your prompt. not to include any content from your client without any authorization for confidentiality reason, because I explained you at the beginning of the presentation, all the information that you include in your prompt could be reused in the training data. Avoid all references to existing creation by using, for instance, formulations such as do an image in the manner of or similar to Picasso. Obviously, if you use that kind of formulation, you take a real risk to infringe a previous work. And do not rely on information generated by the AI without checking that it is accurate and up to date. Here, this is a list of things that you can do. Consider as an artist, consider the generative AI as a production tool and not as a final creative solution. So it means that you should remain very creative in your prompt and rework the output. Really like spend time on the creation. The most time you spend, the most easy it would be to claim protection by copyright. Take a critical look at the content generated and do not hesitate to carry out checks to ensure that this is not similar to an existing work, even if I know that practically speaking, it could be difficult. And include specific provision in agreements with your clients. I'm thinking about limiting your liability. Other recommendation, you can follow training to know how to prompt. Today there is a lot of training for the artist, amending contract with employees or internal user charters to include provision regarding the use of AI in the creative process, amending your generic terms, also to include specific clauses, the use of AI, and be transparent and communicate with your client about your approach on the use of AI. It is important to be transparent and to tell your client, okay, I'm using AI as a tool, and I do not hide it. Then the last part, but Séverine already introduced this question, but how to protect an original work generated with AI. So as Séverine explained before, pursuant to French and EU law, copyright can only protect work made by human and not by machine. However, it does not mean that any work created with the assistance of AI cannot be protected. It's just a question of course, for instance, if you only do one prompt, okay, and you just use the output as your final work without any input from you, without your personal touch, of course, it could be very difficult to claim copyright. But if you spend time on the creation, you rework, you readapt the output, then it might be possible to claim a protection. So my advice would be to constitute a file, including all the steps of the creative process with date, and clearly distinguish the human intervention from the AI contribution. Keep the control on the creative process. You really need to be the originator of the work. Keep an history of your prompt too. It is also important to demonstrate that you didn't make only one prompt, but you really spent time to create this work and to modify it, to transform it. So this would prove the human intervention in the work. Thank you.
Thank you very much. Mathilde, my question to the audience is, if you have questions, if you're online, please keep putting them in the chat. And we have two more presentations that will be brief before we have a Q&A. Thank you very much for the practical tips and for explaining the input-output process. It's kind of interesting that the prompts that you're describing are texts for our purposes to create images. I'm not sure if they're image prompts that exists or it's unclear.
No, you can include an image in your prompt to readapt an image that you have in your file, but yeah.
I see.
Otherwise, it's only a text. Yes.
All right, so there's a lot of food for thought, a lot of different data sets that are being used. And it seems to me that the way you're explaining it, it makes it very clear. And then when we look at the mess that we actually see out there in the world, it's confusing why the creators and the data set makers are not able to be as clear and organized. All right, so in addition to our as promised speakers, we are very fortunate to have Noor, who's joining us from London. She offered to discuss what UK has been doing since it kind of exited, but never exited European family. If there's anything that we can learn from the way UK is treating this subject. And then we'll wrap up with a little review or some extra food for thought on the pending litigations out of New York. And then we'll have our discussion. Yes. Yes. I hope you can hear.
Thank you very much to the Center for Art Law and Technical Fisher for this event. I've got to say I advise on copyright sometimes in the art world, but I'm not an expert on AI. I don't think many people are, even though some profess to be. I must say though, it does actually scare the hell out of me sometimes, and so it's getting to grips with what exactly it means, as well as how we should regulate it to different questions. I also happened to speak to a friend of mine who's an artist before this event, called Martha Fiennes. She's Rafe Joseph Fiennes' sister, and she creates a lot of digital related artwork. She's actually speaking about this topic at the Hay Festival in the UK. I mean, she said that we have worked long and hard as artists to protect against infringement, but she used the word, this is a tsunami that's about to hit us, and no one knows what's going on, and everybody's trying to create codes and laws to regulate it. I also happen to be an English lawyer for my sins, and coming from a jurisdiction which thinks it's, you know, setting the precedent for everything and doesn't need to change sometimes, relied a lot on the development of case law, unlike in civil jurisdictions, which codify a lot of things. And so for that reason, it may become complacent in certain areas and feel that it has adequate laws that govern certain areas, but those laws do need to keep up. And this is one example of one area. So basically, it's interesting to hear about the US position and the EU position, because we'll compare and contrast with the UK. The UK likes to think of itself as being at the forefront of, you know, everything, and the pioneer of everything. And maybe 30 years ago with the UK Copyright Designs and Patents Act, which still covers copyright and also AI. Perhaps it was correct 30 years ago, but that was a different time. And the point is, last year, a UK committee was convened basically to see if certain regulations were adequate in this respect. They concluded that the issue is that the AI related, I mean, the protection, which we'll go on to cover where it is in the Copyright Designs and Patents Act, isn't quite adequate for what AI has become, because what AI is now is less of a tool that aids the creation of works, but it's rather what creates the works, and it's next level. So their recommendation was, look, UK government needs to do something, needs to update this act. In many other ways, it needs to also be updated, but we won't go there. So the UK, the government issued a white paper, March of last year, called A Pro-Innovation Approach to AI Regulation. And it set out what the UK proposed to do in relation to the regulatory framework for AI. Unlike the EU's AI Act, which does create new compliance obligations for a range of actors, the UK's approach is to develop more of a principle-based framework for existing regulators in different sectors to interpret and apply within their specific sector domains. So it encouraged a consensus to come out of those regulators and to come up with a code to govern AI. I'm not going to go into what is AI, right? You know, I guess in terms of every jurisdiction is different, but we've heard from the US and the EU position. The 5 principles that they wanted to do, you know, kind of promote in relation to this code is safety, security, and robustness, transparency and clarity. And let's face it, the law can sometimes be completely untransparent and not clear. Fairness. So, you know, balancing the rights of artists as well as the rights of those who do want to legitimately develop models that can use others' images for fair use, for instance, and things like this. Accountability and governance, and contestability and redress. The problem is that, you know, although the code, if it had arisen in the UK, would have made licenses for data mining, which we talked about, more available. Because right now in England, data mining, I mean, it's not covered. It's not possible. It's not the same. It doesn't exist the same exception as was described under EU law. So it would have made licenses more available. It would have helped overcome barriers that AI firms and users face, and as well as ensuring protections for artists, rights holders, people like Martha and many other artists like who we know. And so that the UK copyright framework would promote and reward that investment in creativity. But the problem is the IPO working group could not agree on an effective voluntary code of practice. So as a result, we are still left with the regime under the Copyright Designs and Patents Act until such point as there is consensus and we know what a potential code could say. And so legality of the use of copyright materials and AI models, ability of content creators to monitor and police the use remains unresolved. What is the position in the UK? So right now, AI developers are not allowed to copy third-party copyright works in the UK for the purposes of training AI models. That's so under Section 29 of the Copyright Designs and Patents Act. There is an exemption to copyright for non-commercial research. But let's face it, a lot of the time you want to commercialize the practice. The UK did not. We talked about the EU copyright directive allowing the opt-out. So the UK did not transpose the EU directive, big surprise, allowing the opt-out of the commercial use restriction. So right now it's quite stringent. You can't. So for now, such use is infringing and is subject to license fees. So that's a good message for artists wanting to relocate to the UK. They can, anytime they see their work being, you know, they need the license fee. There is no opt-out, and that can't be imposed on them. But the section 178 of the UK Copyright Designs and Patents Act. So what is actually copyright protected? And this is what comes back to what the position was 30 years ago and what it remains. 178 of the UK Copyright Designs and Patents Act enables copyright protection in works generated by a computer in circumstances when there is no human author of the work. That's computer generated work. So AI will, where, you know, you ask where is the AI treated in UK law, in English law, that's where it falls under 178, because AI will fall under computer generated work. But since copyright cannot vest in machines or non-human actors, the resulting author of a computer-generated work is the person by whom the arrangements necessary for the creation of the work are undertaken. That's section 9.3. And the case that you can look at is Fowler versus Comptroller General of Copyright Patents, Designs Act and Trademarks. Patents can only can also only be granted to humans. So again, Séverine talked about the really interesting case of Zaria of the Dawn. And here comes the distinction between the US and UK law, English law. I keep saying UK law, but I'm Scottish and I know Scotland. Scottish law is something different. So in there, you know, if that artist had been here, she would have been potentially protected, the whole work, including not just the text, but the images. Because there is a higher threshold of a sufficient level of human authorship is needed in the US. And in a way, you can say that the US in that respect is maybe a bit further forward in recognizing the challenges and the risks that what AI is now can be, which is that the issue is it's not just a tool, it is actually a method by which an artwork can be actually generated, and it's not used as a tool by a human being who is applying a sufficient level of originality. So because we're still within the concept of the Copyright Designs and Patents Act, under that, the author of Zaria of the Dawn would have probably received copyright protection in England. What else to be aware of? Copyright protection in relation to these works, AI, computer-generated works, is reduced to 50 years. No such thing as moral rights apply as well, because as we know, moral rights is a very, very important part of artist rights, IP rights. The language of the Act is unclear as to whether the threshold of originality requirement in copyrights to apply in traditional works is of a high or a low standard. So again, going back to the cases in the US, again, there isn't much case law. And again, you know, to reiterate the point that the English law really does depend on developing law through case law. So we have to wait and see. Everything is to an extent subjective. We've just seen from your presentation, some of the images you showed were very clear to some of us, such as in the, you know, the Dune one. But then the last one, divided. So how can we do that? Can we actually be more clear in the code, or, you know? The law is also unclear on the line drawn between computer-generated and computer-assisted. And the other thing is, copyright is a territorial right. And going back to the Getty Images versus Stability AI, the interesting case is that Getty Images and, you know, the claimants have you know, started legal actions everywhere, including in the UK. So again, a case to look into, because this is the one case in which I would say, I mean, I looked for case law, and really there's really not much of it. This is the case, and that will maybe set the groundwork for what may come, and what, you know, what the basis of code will be. Because we went into the back, I don't know, not in a lot of detail, but Getty Images and other claimants claim that Stability AI scraped millions of images, and again, it related to the use of the prompts and synthetic kind of, you know, production training of the models. What happened was Stability in the UK tried to dispel this action through a summary judgment procedure, saying there's no merit in the case, just throw it out. And the judge disagreed and said there is a prima facie case. We should allow this to go forward, and do keep an eye out on what is decided, because this case is going forward through to the Court of Appeal. We won't go into the different defenses that Stability has. Basically, they deny that copyright was infringed. They also say that if those primary defenses fail, that they will alternatively seek to rely on the exception to copyright infringement provided under the Act, which is pastiche. So that's an interesting kind of alternative argument, because Section 30A of the Act provides that fair dealing with the work. I mean, in the UK, and it's very interesting talking about fair use versus fair dealing distinctions. In the UK, it's fair dealing. So what the argument is that fair dealing with the work for the purposes of caricature, parody or pastiche does not infringe copyright work. But then as a very preliminary minimum, that accepts that the AI generated is treated the same way as other material that is then used and then, justified on the basis of pastiche. So this is very much an alternative argument. Their first argument is, look, it's a machine, it's prompts, we don't have control over it, and it's for training, and this is not a copyright. The essence of their argument also, and this is why it's very important to highlight, where are you based, is that the activities complained of by Getty and the claimants took place outside the scope of UK copyright law as it took place outside of the UK. So again, let's see where it goes. The summary judgment was denied. There was a reasonable prospect of success. As I said, training and development of a model would not constitute an infringement under English law if the process didn't take place in the UK. Right now, if it did, then it would constitute an infringement. But controversially also, the secondary market aspect of this case was interesting because the judgment left open the possibility that an AI model could qualify, an AI model itself could qualify as the infringing copy of its training data, and suggesting that the stability AI model could be embedding a copy of its training data within this. And again, don't ask me about tech and how this works. The idea is secondary infringement of importing, possessing, or dealing with an infringing copy. This is a type of infringement. Secondary infringement is a type of infringement traditionally reserved to tangible objects. But the judgment implies that this may be capable of extension to intangible information, such as making available software through a website, thereby showing the court's openness to a departure from the traditional methods of protecting against secondary infringement. Which again goes back to the fact that unlike in Europe and in civil lawyers, you're looking at code, you're looking at what's been passed, what's new. In the UK, you have to look at certain decisions of judges in the case law, and this might not be very apparent. There's not going to be like a news article necessarily in every case that comes out. It's only when you read the judgments that you see, oh, there's this judgment changes things. So I really would recommend following this case and what does the court basically hold. So I guess I would say watch this space. It will come. I think the UK, the English, in many ways, it's a kind of a wait and see what's going to happen. I think the bigger issue, and this is something that Martha, the artist, talked about when I spoke to her. She said, look, there are different levels of threat. I mean, I asked her from a perspective of an artist. It would have been good for her to be here, but I said, okay, if I'm to ask you a question as an artist, what do you perceive as a threat that AI poses? And she says there are two different levels of threat. There's the primary threat, which every artist is concerned with, every content creator is concerned with, which is that the ability not to be able to use one's product, just yesterday, Scarlett Johansson, they used her voice without her, I mean, scary, right? Without her permission, OpenAI, essentially. Now, OpenAI took it down. She said, this is not what I, authorize, this is my voice. This has other implications, of course, which are sort of Orwellian in, nature. But there's that primary threat of this belongs to me, I don't authorize you to use it. But the second is more of an existential type threat, which is that what is this leading to a dystopian type of environment where we lose control over what we can create, but we may also lose control in what we can ascertain to be an original work of human authorship, like the images that you showed us of the robots. Well, not the robot. Well, anyway.
The baby?
The six Ultraman.
Yeah.
It's our ability as human beings to distinguish between the machine and whether that machine actually then takes over, and to what extent our creation, content creation. And it's not necessarily something that law will solve. It can actually put its handle on and regulate. And it's quite dystopian, and think, you know, think Orwell, think The Matrix, think all of these things. But at the end of the day, what we are confident of is at the end of the day, there is still a level of humanity that AI cannot replicate, that we will always be able to distinguish between that which was original, that was created by a human, and that which wasn't. And so we are positive at the end of it all. And that's, I guess, my last existential related, AI related issue to raise, which doesn't really have anything to do with putting a code on it.
Thank you, Noor.
Thank you.
Thank you very much. So I'm very pleased that we have gone a little bit out of our original planned format. Because really this was a spy mission. We wanted to know what AI Act was really going to do for the entire world. But because Noor talked about UK, now we know that Thaler that I mentioned to not only sued in the United States, which we all thought was terrifically interesting, but he also sued in the UK, which somehow I personally and many of my colleagues have missed. So it's very interesting how artists and creators are using different tools to try and get their points across. So we have to research that part. The last guest that I am pleased to introduce is Athrea Martour. She is joining us from New York, and she is going to wrap up a couple of themes that we have discussed, and hopefully you are going to be ready to ask your questions. Athrea, are you ready?
Yes, perfect. Thank you so much. I will share my screen now as well, and hopefully you are able to see it. So thank you so much to all the presenters. This has been really, really enlightening for me as well, just learning about how it's been working in different countries and what the law has been. And the tone for my presentation, my very short wrap up of a lot of what we've already discussed, might be a little different, talking a bit more about what we're seeing in the US and a lot of what we're seeing in terms of creative collaboration with AI and with human artists. So what you see on the screen right now, I did generate this with artificial intelligence, and I do say a little hesitantly that I was very happy with this, and God knows I could never be able to paint something like this myself, but it was nice to see that something I had in my mind just as an idea could be rendered onto this piece. But what we're going to discuss very quickly today is just about what we're seeing in the US and a couple of art exhibits that I've had a chance to see. And I thought I would mention, I visited this human-assisted AI event, and what I saw over here was this poetry camera, and it was a Polaroid camera, but when it captured the image, it would print a poem instead of a picture. And this was run on artificial intelligence. It was run on Raspberry Pi and a thermal printer. And it produced poems that were really, really specific to the people who were standing in front of the Polaroid camera and who had their photos taken. And it was really interesting to learn just today that they released Poetry Camera 4.0, and they're actually making the open source information accessible to everybody with all of the instructions on how to create your own poetry camera. And they're going to be giving little do-it-yourself kits as well, so that people are able to collaborate with the camera and collaborate with artificial intelligence and not only build the camera themselves, but tweak it to produce poems with the help of artificial intelligence in the way that they would like to. So that's one of the examples. At the same human-assisted AI-generated art event, once again, to stress upon the name, I saw this piece, which was called Taser Chess, and it invites the human player to play against artificial intelligence, and you attach this electrode pad onto your arm, and then if you play some poor moves or some bad moves, it gives you little real-time feedback through shocks. So it trains you to do a little better while playing chess. And this was just another example of something that we're seeing people create and how excited and interested artists are to work with artificial intelligence to create something that they may not have been able to create earlier. And I just want to mention that copyright aims to protect artists and promote economic rights. And it also promotes progress of science and arts as well. So there's a lot to discuss in terms of issues that we're seeing, which the speakers have already presented on, so I won't really go into this, but we are looking at who the author of the work is, who's the owner of the work, who has rights over these AI-generated works, and whether they're ultimately ever going to receive any protection. As the previous speakers mentioned as well, artists are concerned about a couple of things. One is that they are nervous that artificial intelligence is going to replace the work that they do, and they'll lose on commissions and contracts because of it. Another set of artists, especially digital artists that we've spoken to, they were excited to collaborate with artificial intelligence. They realized that their work was being fed into AI, got very upset about it, and stopped collaborating with artificial intelligence. And there's another sect of artists who are once again wanting to learn how to create with AI, and they are creating with artificial intelligence, but they want to be sure that they can protect this work as well, because they do believe that what they're creating is very, very creative. So that's in terms of authorship and protection. The other half of it, as mentioned, is about infringement and fair use, about data scraping, whose work is being used to train artificial intelligence. Is it work that's copyright protected, pre-existing? And if it is, would this be considered as transformative or fair use? There are a lot of other issues that were discussed, like creating the likeness of an artist and the right of publicity that could be implied as well. We have issues of data privacy, data retention, and also a lot of racial bias in training that we can probably talk about in a whole other conversation. But I'm trying to cover what we are seeing, a bit about the Copyright Office registration letters, about class action lawsuits. What are the companies and the big tech AI companies doing? What we should be concerned about? And is there a way forward? I won't really go too much into this because we've already talked about Zarya of the Dawn, the graphic novel that was initially granted full protection and then copyright protection was rescinded. And it was only granted to the selection and arrangement of the images and texts. So as you know, this was a comic book and it had images and these little texts as a comic does. And ultimately, the Copyright Office said that the selection and arrangement of these images with the text together would be considered copyright protectable, and whatever was created by a human author would be granted protection. So the images in itself that were generated by Midjourney were not granted protection. Now, this is important because after the Zarya of the Dawn registration letter and the rescinding of the copyright protection, the Copyright Office established certain guidelines. And essentially, it's that the author has to be human. And the second is that if AI generated material is there, it can't be just a mechanical reproduction, and it can't just be something like a text prompt. So there can't be just influence. There has to be substantive creative material which the human author is contributing to it in order for it to receive protection. Finally, selection, arrangement, and coordination of that material can result in anything that could be copyrighted. But once again, only to the human added elements like the text that we saw in the previous example, and not just what has been generated by artificial intelligence like the images in Zarya of the Dawn. Finally, the application that all of the applicants, they have to disclose that AI was used in order to generate the images. And this becomes really important for multiple reasons. But the same artist who created Zarya of the Dawn, Christina Kashanova, she also created Rose Enigma. And this is still pending protection, but they're fairly confident, the lawyers are fairly confident that they might be able to receive copyright protection from this. And the reason why this is different, though it's difficult to say what the Copyright Office will decide, is that a hand-drawn image of a head, a cyborg with flowers emerging from the head, was included by the artist, which she had drawn with a pen, and she exercised a lot of creative control. She included the pen drawing, there were specific text prompts, and there was a use of a separate tool. And she also did specific seeds in order to control the way the viewer sees the image that's generated. So after she inputted her artwork, after she inputted the text prompts, then she received this image. And this is what she's trying to get copyright protected. And like I mentioned, this is still pending registration from the Copyright Office, but it's exciting to think how artists are wanting to test what is human creativity and how much human creativity is required in order to protect a work that they believe is creative enough and they've spent their time on. We've also already discussed this. On the left, you see the very first version of the image by Alan, Theatre d'Opera Spatial. And on the right, you see the final image, which he had really worked on with Photoshop, different text prompts, and this image that you see on the right, it won a competition in Colorado. People were very upset because it was known that this was AI generated. Ultimately, he had to forfeit the prize. When he had applied to get this copyright registered with the office, he hadn't disclosed that it was AI generated or any components were AI generated. So the Copyright Office had responded saying that because the amount of AI generated material was more than de minimis, he had to disclose the use of artificial intelligence in creating the work. He never took it forward, but ultimately this was not granted copyright protection just based on the information that we have. Irina had briefly mentioned some of these, and I mentioned this as well to show you in the previous case that this was artwork that was generated by AI and it was included in a competition with other human artists. So now there have also been a lot of competitions where AI artists are competing against other AI artists. And you can see a couple of them over here, but on the left, there was one artist, Hannah Silver, who had generated an image with artificial intelligence of a robot marrying a tram because the robot and the tram love each other. But Midjourney did not produce that. It produced an image of a robot marrying a man. And ultimately, this did win one of the competitions, but it's interesting on what she commented, saying that that's the fun of AI. You never know what you're going to get, which is interesting because maybe it's not as easy to produce something so in detail and to the point as what the previous artist who tried to copyright Rose Enigma had done. An artist that we had recently spoken to and that the center interviewed, and you can read her interview on our website, was Colleen Hoffenbacher. And what she told me is that she was inspired by artificial intelligence. And on the left, the top left that you see, there are two images that she had generated with AI. And she was quite happy with them, but she wanted to make them her own. So she recreated those images, which she was really inspired by what was created by AI. And she used oil painting and aluminum panels in order to create the newly generated works, which you can see on the right and a close-up on the lower left corner. So these images, region 1.02, which you see on the right, was granted copyright protection. And of course, that does make sense because this was human creativity and oil paintings and all of these materials were used in order to produce something, but it was inspired by these images generated by artificial intelligence. Just something to think about. Another example, on the left, you see Klimt, the Kiss, and on the right is a different rendition of the Kiss in modern day. And this was just a prompt that was entered into DALL-E to see what we could get, reimagining old paintings and old images. And one of the important things that becomes necessary for artists or anybody who wants to test out artificial intelligence to understand is who owns the work and what you can do with it. Right now, unfortunately, as we all probably know, at least in the United States, the law isn't catching up to how fast artificial intelligence is being developed. And a lot of times we're relying on what the websites are saying. We're looking at the user agreements and the terms and conditions on OpenAI's website, Midjourney's website, and what exactly they're saying about who gets certain rights. So a lot of times on these websites, intellectual property and copyright is not mentioned. But what they do say is that the person who enters the text prompts, they retain the ownership rights. And what they also say is that when you generate these images, when you generate any of these works as the text prompt inputter, you also have the right to create and commercialize these images. So you can print them on tote bags, you can print them on canvases, and you can sell them according to the terms of use on all of these websites, including OpenAI. Once again, a little hesitant, but I did print some of the images I made, and you can see a lot of the work in the background. Tons of legal and ethical considerations that we've discussed and that we probably will discuss more. but just as an idea of who owns these works and what you're allowed to do with them, and the issues that could arise if you do something with them. One of the issues that we have seen was an artist, Kelly McKernan, who reached out to us. And this was about a year and a half ago. And she was one of the digital artists who were super, super excited to create with artificial intelligence. And she was looking forward to the release of DALL-E in summer last year. And like I said, she was excited to create until one day she was on Instagram and someone tagged her in a comment saying, "Hey, I love your artwork here." But it was not Kelly's artwork at all. It was very similar to the work she had created, and she was very surprised to see her work, which other people assumed was hers, shared on Instagram, but created with artificial intelligence. Kelly McKernan actually spoke at our conference last year as well. And one of the original image you can see on the right is of hers. And on the left, one of my friends generated these images during the conference while she was speaking in a matter of 30 to 40 seconds. And we were able to produce these 4 images in the style of Kelly McKernan in less than a minute. She was part of one of the class action lawsuits against Ability AI, against OpenAI. And unfortunately, because her work wasn't copyright registered, she wasn't able to continue on her claims. Only one artist has been able to continue, and that's an important point to note, that if you want to file any lawsuit against another party in the United States, your work has to be registered in order to bring a suit in federal court. Very quickly, another case that is pending is, of course, the case of New York Times versus OpenAI. And New York Times had sued OpenAI for mainly accusing them of using millions and millions of its articles without permission to train their chatbots and to basically provide information to others. So what the New York Times stated was that there were a lot of instances where ChatGPT, for example, was able to give verbatim excerpts of its articles when it was prompted. OpenAI's response to this was kind of funny. They said that what the Times did is that they paid an unnamed hired gun to manipulate its products and to reproduce the newspaper's content. They were saying that what New York Times did is that they hacked into ChatGPT in order to get these instances of infringement. But the Times responded that it had only used the first few words or sentences of its articles to prompt ChatGPT in order to recreate them, and ChatGPT was able to recreate them in a whole. When I was researching about this case in general, I found this really funny and interesting comment on Reddit. Just once again, commenting kind of on how long these cases might take, and once again, how fast artificial intelligence is being developed, much faster than we're going to be hearing these lawsuits will play out. So one of the comments was that, how long is it supposed to take? 3 years, 5 years? Will it even be relevant when it's done? Google versus Oracle took 11 years. And then another comment is that it'll last for many years. At the end, Microsoft will either buy the New York Times or win. So it's interesting to see what people are saying about this and what their thoughts are on about this as well. I'm not sure if we have the time to go into more of this, but you can look up Ben Moran, and I'll include him in the materials as well, but he was banned from a Reddit community for being accused of creating AI art when it was actually human-made art. And then the moderator for the community had said that, well, that doesn't really matter because no one's going to believe you if you say it's not artificial intelligence, and AI can do it better in seconds what might take you hours. And he was really upset about this because this community was created to protect human artwork. There are a lot of other issues which I probably won't go into, but what we're seeing is that an ethical and collaborative approach for artificial intelligence might be a possibility. AI seems like it's here to stay, and we have discussed a couple of these during the presentations today as well about informed consent, opt-in and opt-out mechanisms. A lot of concerns about making sure that artists, for best practice, are watermarking their images or providing low resolution previews. A couple of interesting things that are also being done by art professionals. We once again had interviewed Andy Rosen, who had founded this software called File Protected. And what File Protected does is that you can register your artwork on blockchain. And this is very different from copyright registration, but what this allows is for the person who's registering the work to have some kind of track of ownership and to track the creative process and when certain things had happened in that process. So a lot of artists are trying to register their work on the blockchain to show some kind of ownership, though of course copyright protection isn't granted. There's also a tool called Nightshade, which is very, very interesting, very cool, sometimes concerning, and it's a data poisoning tool. And essentially it tricks the user into thinking that it's one image, but it tricks it into thinking it's another. So suppose you have an image, an artwork of a dog. The code will trick you into thinking that it's an image of a cat. So when it's inputted into any learning platform, or if it's being scraped from the internet, you won't be able to actually produce the same image again because it believes that it is a cat and not a dog. Finally, just to end and to wrap up, I know we're running out of time and sorry about that, but Irina, don't kill me, but there was this one meme which said ChatGPT is going to take over your job, and it's like, me, take it. And then there's another meme that said that humans doing the hard jobs on minimum wage while robots write poetry and they get to paint isn't the future I wanted. So these are, once again, a few thoughts that I just wanted to share from what we're hearing, what we're seeing from the community, from lawyers, from artists, from art professionals. And it's interesting to see what will happen next. Like I mentioned, we are waiting to hear back from a lot of the cases, and going into each of these could take a whole session in itself, but I'll hand it back over to you. And if there are any questions, always happy to answer.
Thank you very much. All right, we are over the time a little bit, but I think if you have questions and comments, I think we have, we're here, we have the experts, and the takeaways can't be, this is a mountain of information that we can't work through. The mountain is going to keep growing, but I think if we parse it out, we can deal with it. And if we work together, we can deal with it faster, perhaps. Nora, you wanted to say something?
I wanted to say it's very interesting, the Kelly McKiernan question, because you said that you didn't have to register. I think most people probably know, if not, then in the UK, you don't have to apply to register copyright. It arises automatically.
Yeah, it's the same in France.
Well, no, in the States, you don't have to apply, it arises automatically, but if you want to sue, you have to have copyright registration.
You have to have a copyright registration.
This is not the same in France.
Same thing.
So before the program started, and I invite you to think of your questions, before the program started, Mathilde said, oh, our president recently said, we need to have more trainings about artificial intelligence. I'm glad we are serving or aiming to please, and we're doing a training on artificial intelligence. What questions could we answer for you, or what comments would you like to make on what you heard today?
I have one question concerning moral rights. I think you mentioned it briefly, that in the UK you don't have protection over moral rights when it comes to copyright. How does that work when the images of artists are being used to train AI with? Do they have any attribution right, like the right to authorship?
Well, the images, the underlying images, obviously, that are being used, the creator of those images does have a copyright in those images, obviously, and they have more rights. But if an output is made, is generated that is copyright protected from an AI model, that doesn't generate moral rights for the arranger behind the computer machine.
But how, like, that's more, I think, focused on the output, but when it comes to the input, when the AI is trained, like the modeling, and they use certain parameters to establish how the output is created, how does that work? Because I think to train AI with, you need certain images to be trained on. Like, how does that work?
The argument of a company like Stability Diffusion is that it's a randomized process, that no thought was taken in terms of using certain images. I think obviously it doesn't even have to be AI. Whoever produces a work, whether it's written prints or a model, if it's determined that a certain image was taken intentionally and manipulated, that the underlying image, obviously, to an extent, depending on basically does but benefit from protection. I think the problem is a lot of people don't know So the thing is, part of the issue is also some of these models, people don't know how that they work.
No.
In the case of Scarlett Johansson, her request was, how did you do this? I mean, how did you even create my voice? I want you to tell me the process. And now the thing is, we never got there because ultimately they took it down. But that's, for me, I don't know, it's not enough. It's not enough. You shouldn't stop there. You should say, no, but we need to know, how did you do this? Because it can't be available to a certain section of the community who understand it and can create it the same way as they maybe understand blockchain, you know?
So right now, there's not a lot of transparency insofar as knowing how the workings of the.
Yeah, exactly. Yeah.
Séverine, do you want to comment?
Yeah, just to comment on on the use of voices, because I think in the case of Scarlett Johansson, actually, what I've been reading today is that they actually hired an actress to lend her voice, and the voice is not the one of Scarlett Johansson. So, it might be that actually it's not Scarlett Johansson's voice at the end, we'll see. And the thing is that there are a lot of concern in the music industry, because it's true that you can create music with the voices of performers very easily. And there, I think that it will be very easy for many reasons to get some result in court, and it will be an infringement of performers' rights, because it's not like the voices of artists are just included in a vast amount of a vast repertoire or recordings, is that they are specifically used to generate that new song by that artist. So because they will still be individualized in a way, that will be a completely different matter than using the images. There might be, and actually this is, someone tells that yeah, the time here is important, because the generated AI system are changing all the time. And actually we can see today that there are some generative AI platforms or operators that actually will propose the use of the generative AI tool with some specific data sets. And so they might say, okay, we will provide you a license to use generative AI, but if you want high quality data set, we can also annex to that the New York Times data set. And of course they will do that with the license and authorization of New York Times. So I think that the market is just emerging, and there will be market to propose specific data sets on license terms, and that will be completely different. But at the end, single artists might be completely lost, because defending their rights or their own creation might be very difficult, while big producers of information sets like Getty Museum, like New York Times, like whatever, like the music industry, they will get the agency to actually negotiate license for the value they will bring to the data set.
Going back to your subjective point, does it go also to what you were talking about,
exactly.
the do's and the don'ts, and what are the prompts that you put in?
Yes. No, yes, and I totally agree with Séverine on the fact that it will create an issue for the individual artist, which doesn't have the same power to negotiate with AI operators, of course. So only big companies such as Le Monde in France or the New York Times can negotiate licenses. So, yeah.
There's also a parallel with NFTs as well. So when you're creating an NFT, you have always the underlying sources for everything that's generated. You need to check if you have a license, and if you're selecting that, specifically selecting it. I mean, I think the issue also is the accountability issue in AI. Because when you were talking also, Atreya was talking about the artist who couldn't sue because she hadn't registered.
Mm-hmm.
I mean, there's not much of a difference in the sense of someone could have painted like an exact kind of copy of her works. It doesn't have to be an AI model, but the fact is, when you can go after a person in that regard as well, and who do you go after? Who is the author of the model? I mean, it could be like teams, right? Like many people.
This
Something
subject,
to also add, so sorry, something to also add in terms of accountability. OpenAI, Google, a lot of platforms have also introduced something called Copyright Shield. And it's a little concerning for artists who have been afraid of artificial intelligence and who are nervous about their work being fed into AI, because essentially what OpenAI and other platforms are promising is that if somebody who uses their platform and uses ChatGPT or generate some image or artwork on one of their platforms, then OpenAI would cover any costs of intellectual property copyright litigation that would arise if somebody sues the person, the text prompter who's entering those texts into the system. So Copyright Shield is something which has been introduced recently so that these software companies are giving some kind of guidance to people who are using their softwares and giving reassurance that what they are doing, they think they are fine with it and they would protect their users.
thank you. I think we have to wrap up, unfortunately. There are many questions still on the table. I do hope you have learned something today. It can be a lot, it can be a little. Maybe you will share some of your learnings with us. Thank you all, and thank you very much to Phil Fisher for hosting this really interesting discussion. For those of you online, we wish you were here, but maybe next time. And for those of you in the room, we have a reception, so please stay and mingle. Have a good day, everybody. One thing I wanted to mention, we just published an article about generative AI and transparency, how data sets are also treated as an asset, and we don't want to necessarily release information. So take a look at this article, take a look at other articles, share your research and findings with us. We love sharing it beyond. And on this note, many thanks to everybody who's contributed, to Rachel, to Australia, to Séverine, Mathilde, and Noor, many thanks, and hope to see you again in Paris or online or in New York soon. Thank you.
Thank you.